Hello, everyone. Welcome to our webinar entitled UK Immigration Essential Updates for Employers. My name is Ruth, and I'm a senior associate at Clark's Legal, and today I'm joined by my colleague Monica.
Hi everyone, I'm Monica, trainee solicitor with Clark's Legal, and I am assisting Ruth with immigration.
We've recently received a lot of inquiries from different clients and prospective clients asking us questions about essential updates to immigration. There has been a lot of noise in the press recently about immigration and how this is affecting everyone, not just on a global scale, but also personally. We have decided to conduct this webinar to address a few of the key questions that most of our clients ask us. So essentially, this seminar will cover: when did the key changes affect businesses come into force? What are the recent changes introduced by the Home Office? And how do these changes affect your business and employees? Why did the Home Office introduce these changes? Any potential changes that the Home Office are likely to provide?
And we will also touch upon some of the frequently asked questions that we have received in the past few months from both our clients and existing clients and potential clients via inquiries.
So, what were the changes enforced? As we all know, 2024 was a key fundamental change in the political atmosphere in the UK. We had the Labour government coming into power from July 2024. Prior to that, the Conservative government had introduced a lot of key changes that had affected immigration, especially with the Statement of Change 2024, which increased the minimum salary threshold. After the Labour government came into force, there were also significant changes that were introduced, such as the sponsorship license rules. Under the new provisions that started from the 31st of December 2024, level one user requirements has slightly changed. I know some of you do have sponsorship license, but for our new prospective clients that have joined us in this webinar, a level one user is the key administrator of the sponsorship license. They have the responsibility of running the sponsorship license and reporting key changes to the Home Office. The new changes now provide: when applying for a sponsorship license, sponsors must nominate at least one level one user who is: one, an employee, director, partner of the organization, and this person needs to be a settled worker. What is a settled worker, you might ask us? Under Part 6 of the immigration rules, the Home Office has set out to define who a skilled worker, a settled worker is. A settled worker is an individual that has British citizenship or has indefinite leave to remain. This also applies to European citizens that have settled status in the UK. Under the new requirement, the level one user must meet the above requirements throughout the life of the license. As Monica and I have recently discussed, a lot of the prospective level one users that are coming forward are actually disclosing that at some point during the license they would want to leave, but that's not what the Home Office are advocating for. They have to make sure that that individual meets this requirement throughout the life of the license. We have also been facing frustrations as legal representatives because the Home Office has now recently disclosed that there's a restrictions on legal representatives being listed as the level one users at the initial stages of the sponsorship license. We can only be added after the sponsorship license has been granted, and that is a process that we would normally assist you with if you need our assistance. So, one of the key changes as well that has been introduced is in relation to the recouping of sponsorship license costs. Monica and I will explore what these costs are. Essentially, employers are no longer permitted to recoup certain sponsorship license costs, such as the sponsorship license fees, the immigration skill charge, and cost for the certificate of sponsorship. We've recently emailed a lot of our clients updating them with the changes in the fees that the Home Office has implemented. It is now unlawful for employers to recoup these costs that we've just spoken about, you could find yourself facing liabilities if you do. So when were the changes enforced? You've heard me talking before about a statement of immigration change, which we were speaking about, the 2024 Statement of Immigration Change. On the 12th of March 2025, the Home Office also introduced a new statement of change, which brings significant amendments affecting multiple visa routes. What is a statement of change, you might ask us? A statement of change is a document modifying the immigration rules. So essentially, the immigration rules have always been in existence, but over the years, the governments have been modifying and changing. And this is the current legislation that we have to look at. One of the interesting concepts that came out of this new statement of change that was implemented on the 12th of March 2025 was in relation to visa requirements for nationals from Trinidad and Tobago. Prior to the 12th of March 2025, individuals from Trinidad and Tobago could come into the UK without any visa restrictions. Now they have to apply for a visa before coming to the UK. Interesting point that the Home Office raised in this statement, but what they were basically saying is the reasons for this fundamental change was because they had witnessed an increase in asylum applications for nationals from this particular country, so they decided to enforce visa requirements for them. Another sad thing that came out of this statement is the extension of the Ukrainian scheme. As you all know, the war in Ukraine has been happening. And from the 4th of February 2025, the Home Office has decided to extend the visa route for nationals from Ukraine to a further 18 months, which is also a reflection on how the war has not changed and who is to know what is going to happen in the future. We have recently received a lot of inquiries from employers that have people under this scheme asking when their visas are going to expire. At this rate, we do not know because the war is still going ahead. Another key change is in terms of care workers. From the 9th of April 2025, the minimum salary threshold for care workers now has increased to £25,000. We do have a lot of people that attend in these webinars that have got nursing home or care agencies that would really be interested in knowing this fundamental change that the Home Office has made. As we previously mentioned before, during COVID, there was a lot of concerns and the need for support workers to assist the population because there was a shortage of care workers and support workers in the UK. The Home Office over the years has realized that there has been concerns about exploitation and modern slavery in this particular sector. Sponsors must now recruit from a pool of care workers already in the UK before seeking to recruit from abroad.
And this change seems to bring us back to the resident labor market test, which was done prior to the skilled worker visa route coming into force, where sponsors need to prove that they have done market research and that they tried to recruit within the UK before sponsoring whoever worker they wanted to sponsor from either within or outside the UK. So it seems like the Home Office is going backwards to changes instead of moving forward.
Thank you so much, Monica. We would also like to stress that this is relating particularly to care workers and not all skilled workers. We also saw a lot of information out there about ETAs or ETAs, depending on how you pronounce it. What an ETA is, it's an electric travel authorization, which was first introduced by the Home Office in March 2023. The idea or the reasoning behind it is now non-visa nationals. So they have a list of non-visa nationals that they have can now come to the UK. However, they need to apply for an ETA before traveling. We had a three three transitional period, if I could put it that way. The first was in October 2023, which was all the Gulf nations needed to apply for an ETA. And then on the 8th of January 2025, we saw all the American countries, New Zealand, Australia, having to apply for an ETA. From the 2nd of April 2025, all European nationals now need to apply for an ETA before traveling to the UK. This is not a visa. It's a permission to travel to the UK. We always receive inquiries from people trying to work out if they can use an ETA to work in the UK. It's very, very important that you consult us so we can establish what business activities people would be doing in the UK before traveling, because we have found situations where people are abusing or circumventing the immigration rules and trying to work when they're supposed to be applying for skilled worker visas and not relying on an ETA to come to the UK. There have also been fundamental changes to the EU settlement scheme. Amendments were made to the EUSS, including that all non-EA nationals can now use an expired an expired UK BRP card as proof of an identification. They have been changes with the BRP residence card right now. As we will discuss further on, the Home Office is also saying that from the 1st of June 2025, everyone's status would need to be digitalized and would not be relying on biometrics residence card anymore.
We will now be discussing the changes to the Home Office fees from the 2nd of April 2025 to the 9th of April 2025. On the 19th March 2025, the Home Office announced significant increases to visa and sponsorship fees that came into effect on the 9th of April 2025. These changes have impacted and will impact a wide range of applicants, including skilled worker visa holders, sponsors, and individuals seeking settlement of citizenship in the UK. The fee increase range from £8.50 to a substantial £286, affecting both employers and individuals. Fees for immigration applications are rising between 5% and 7% on average, but some are higher. As we explored earlier with Ruth, now sponsor cannot recoup the majority of the visa costs that they were able to do before. So it's a bigger commitment for sponsors and companies in general to retain talent or recruit talent from overseas. We have outlined some of the changes and key costs in the next slide, and we will go through them with you. So the sponsor license costs for a medium and large organization have raised has had an increase of 7%. From £1,476 to £1,579. For a small sponsor, small businesses, the fee increased 7% from £536 to £574. The certificate of sponsorship, the issuing of a certificate of sponsorship, which is paid per migrant worker, has raised 120% from £239 to £525. For a skilled worker and senior specialist workers, which are the two main categories, visa categories that sponsors usually have on their license, for a certificate of sponsorship of up to 3 years, the cost has raised 7% from £719 to £769. For the same visa categories mentioned just a second ago, for a certificate of sponsorship to be issued for over 3 years, so between 3 and 5 usually, but anytime really over 3 years, the cost has raised again 7%, so from £1,420 to £1,519. For the same two visa categories. Also, the visa fees, so not related to sponsorship, but related to the visa application itself, the costs have increased from for a sponsorship for up to 3 years inside the UK. So if the applicant has already been residing in the UK under another visa, or again a skilled worker visa for an extension, the visa cost will be the visa application fee would be £885, which is a 7% increase from £827 that it was before. And again, for the same two visa categories, for in-country application over 3 years of sponsorship, it has increased again 7% from £1,636 to £1,751. So who do these changes affect the most? Both employer and employees are affected by this hike in home office fees. On the side of the employers, there's more financial responsibilities, as they usually are the ones who anticipate or pay for the sponsorship fees, including visa costs for employees. There is a strict salary compliance that, again, employers have to comply with, and therefore, in certain circumstances, they might have to pay employees more than maybe what's within their budget or what's the required for the role. There's with the fact that they are no longer able to recoup some of the sponsorship costs, such as Ruth mentioned earlier, certificate of sponsorship license fee, and immigration health surcharge. Also, it's more difficult for maybe small businesses who would like to retain talents. And again, costs of sponsorship now must fully be absorbed by the employer, and there is almost no recovery costs from the employees. There's also stricter compliance obligation and prioritization of the domestic labor market, and especially, as Ruth said earlier, within the care sector. And now recruitment planning for employer must adapt to this new cost structure. What are the recommended actions for employers? So we always advise our clients, and we advise all of our prospect clients, to be up to date with their contracts and policies, and to be compliant with all immigration's law, upcoming immigration laws, and that's what we also do for our clients. And one particular aspect that we always advise upon is clawback agreements. So with clawback agreements, employers can recoup some of the cost for visa applicants. The costs that can be recouped are visa application fees, immigration health surcharge payments, maybe biometric appointment fees. And although this may not be extremely high compared to the cost for sponsorship, there's still a way of financial security for employers should a prospect employee or sponsored employee leave the company before the agreed sponsorship period. These clawback agreements, they provide protection for the employers, but also for employees. This ensures that the sponsorship period stays in place for as long as it was agreed upon before sponsorship. Migrant workers are protected from fee recovery. And other financial pressures that they might have, as not everyone is able to afford all the visa fees in advance of the visa application. It focuses also on ensuring fairness and transparency in employment terms. As you might know, and as we always say, employment and immigration go always together. Mm-hmm. In our view, the Home Office rationale behind these changes is to improve compliance from both sides, so from both employees and employers, promote fairness in the immigration process, and ensure a sustainability of the immigration system. And there is also a political dimension that focuses on building the domestic market more than the overseas market. And so that's what seems that Home Office is trying to achieve right now. So what we recommend for our employers, our clients, to always review, as I said, the contract and policies, and to make sure that all agreements in place are reviewed by a lawyer and contain all the correct clauses.
We do have an employment team that can assist you with drafting clawback letters. We all work as a team. Monica is currently also sitting her employment lawsuit at the moment as well. So that is actually a balance. Her knowledge has actually been fundamental to the progress of the immigration team, because we're bridging the two areas of law together. So if you do need any assistance drafting clawback letters, please do not hesitate to contact Monica. She'll refer you to the right people, and she probably would be drafting the clawback agreements herself. Thank you so much, Monica. That was really enlightening. Next, we're going to cover training and awareness. One of my college professors used to say, training is the bridge to action. And it's very, very crucial that companies and employers have an action plan in place. It's important to ensure that internal teams are prepared and compliant with the immigration rules. One of the key issues that we always speak about is most people come to us at the 11th hour when the Home Office has issued them with fines. It's always fundamental to be prepared. HR and recruitment teams should stay up to date with changes with the immigration rules. Regular training helps to ensure correct procedures during the sponsorship process. And this is how we come in. Our team provides news articles and webinars regularly to provide updates to businesses on changes to immigration rules. However, businesses should also consider running mock audits to identify and resolve potential compliance risk before a real inspection. Right now, as we all know, the Home Office has been fining a couple of businesses £60,000 per illegal immigrant. You do not want to find yourself in that situation. Financial planning for sponsorship is also very crucial. We've all had to adapt to inflation and a new cost landscape, unfortunately. Employers now must budget for full cost of sponsorship, including the fees previously shared or offset. Consider how this cost will impact recruitment strategy and long-term financial plan. A couple of businesses do come to us where they're outsourcing recruitment when they do have a strong HR team in place that can assist them. Trust your HR team. They have the tools and the skills to potentially help you. Businesses should also review how benefits in kind may carry tax implication and plan accordingly. We do have tax experts that can assist you. Do not hesitate to contact us if you do need any assistance with tax advice, especially in situations where you're paying for the visa applications and IHS payments for your migrants. We're always here to help you. So, what to look out for in the future? As I said to you before, there's been a lot of noise with immigration, not just in the UK, and that has to do with elections all the time. I'm sure you know there's a lot going on in the States, there's a lot going on in Canada right now, and it's because of the elections. There's legal obligations now for UKVI visa account holders to take actions. A lot of the migrants that you have might have visas that would require them to register an e-visa account. The Home Office initially had stated that from the 31st of December 2024, they were going to scrap all the biometrics card, and this was in line with the changes to the EU regulations. Unfortunately, this deadline that they had set has had to be extended several times, partly because the Home Office has not had the mechanism in place, and also a lot of the migrants have have been struggling to comply with the requirements that are set out. It's very important that you ensure that all your migrant workers or anyone that you know that is a migrant has in place an e-visa by the 1st of June 2025. This is the key dates. There will be consequences for people that fail to comply with this requirement that the Home Office has set, such as visa application refusal, suspension of the ability to generate a share code, which potentially might affect the right to work checks for a lot of your migrants, visa cancellations in some instances, and a civil penalty of up to £1,000. A lot of the migrants that we have and a lot of the employees that we come across do struggle to create an e-visa account. If you find yourself in that situation, or any of your employees find yourself in that situation, please do not hesitate to contact us, but at a cost.
Another change is on right to works for gig and 0-hour workers. This was announced on the 30th of March 2025. That businesses in the gig economy and those using 0-hour contracts, which are usually restaurants in the most part, must carry out right to work checks on flexible or irregular workers. This is also for contractors or anyone else not working full-time or part-time for the company. Failure to comply with the carrying out a right to work check can result in civil penalties for up to £60,000 per illegal worker found, which is as if you were employing someone on a full-time contract, regular contract. Therefore, it is very, very important that right to work checks are carried out on any type of worker and to not rely on third-party checks, and make sure that these are done in compliance with the immigration rules.
Thank you so much, Monica. Another key change that is coming is will start from the 29th of May 2025, which will be in about 3 weeks. This is amendments to Appendix Child Student. We do have a lot of clients that are schools and sponsor international students. We have realized that the economy in the UK has actually been increasing because of the number of child immigrants that are coming to the UK. A lot of these child immigrants that come, or child students that come to the UK, do not have their parents with them, and they have nominated guardians that are appointed to look after them. The Home Office has now included a new definition of who a nominated guardian is. Care requirements for students now include they have to ensure that the care and living and guardianship arrangements that are available are actually suitable for these students. The Home Office must be satisfied that the child's safety and welfare in the UK is paramount. And this goes light with the Children's Act 1989. So again, there is an element of intertwining education, family law, and immigration to ensure that the safeguard and the welfare of children, be it an international children, are paramount. There are grounds for refusal in cases where the nominated carer has a criminal offense. It's very crucial that you always keep up to date with changes in the immigration rules, because this can potentially affect not just your business, but also children coming to the UK. Now we're going to look at the frequently asked questions. Thank you all for listening. I hope this has been enlightening. A lot of the questions that we have been generated from the inquiries that we receive, the conversations that we have. We're always a telephone call away or email away if you've got any further questions about immigration. One of the key questions that we've always received, and the reasons why we've actually set out this seminar, is because we've been asked, what are the main key changes coming from April? We've explored all of this. So this goes with the ETAs that we were explaining, the increase in the cost that the Home Office have introduced, changes to the care worker visas that we also explored, and the fact that you cannot recruit any of the costs that are associated with the sponsorship license.
To follow on from what Ruth has just said, another question has been frequently asked is, can employer pass skilled worker visa costs onto their employees? And the answer is yes and no. Some costs can be passed to the employees, and some costs have to be paid by the employer. As Ruth was saying, the costs for associated to sponsorship cannot be recouped by the employees. These are the sponsorship license fee, the certificate of sponsorship issuing fee, and the immigration skills charge. These are costs that have to be bared by the employers only.
So, what is the new minimum salary requirement for skilled workers? As we explored before, the changes to the minimum salary threshold came into force with the Statement of Change in April 2024, and this was changed to 38,700. We do have other visa categories, such as the global business mobility, which has got a different threshold that people would need to meet. So it's always very fundamental that you do look at the changes to the immigration rules to see if there's any changes or what the minimum salary threshold for each category is.
Another question that goes with the previous one is the minimum salary threshold likely to change? The answer is yes, most likely in the next few years with inflation and all other almost home office visa costs, it is very likely that it will change or at least be in line with the inflation. There was a big jump from in the first change last year in April when it went from £25,000 to £38,700. Do we expect the same big jump? We we don't know, unfortunately, but there is a very high likelihood that it will increase in the next few years.
And if there are any changes, we will definitely inform you. One of the questions that we get is, are there any exceptions to the minimum salary threshold? And the response to that is yes. It depends on a lot of circumstances. There is one exemption, which is for a graduate leave. What is a graduate leave? This is a person that has graduated in the UK, was on a student visa before, and they have an exemption with the salary. They would need to show that they're earning £30,960 a year. Who is a graduate? So it's people that are under 26 or 26 at the time of the application. Basically, the reasons why that age is capped is because you're just at the start of your career. It also applies to individuals that are applying in STEM or have a PhD. So anyone that has got science and would readily look at your job description and your qualifications to actually assess if you do meet the minimum salary threshold. The Home Office also has an immigration skills list. This is a list of jobs that were previously on a shortage occupation, such as people that are teachers, dancers, construction. So all of these people can also get an exemption. What we tend to do as a team is, if people approach us with an inquiry about whether they can sponsor an individual, we will do an assessment to look at what specific sort code would be applicable to them, whether the job description actually falls within any of the exemptions that the Home Office looks at. And we will always try to look at ways that would minimize the salary threshold of 38,700. We really appreciate you all taking your time to listen and to ask these questions. The most important thing is to have a conversation where you feel open to approach us, and likewise, we feel free to provide you with all this training. Clark's Legal is always here to help you every step of the way. Thank you so much. We hope you have a lovely day. Thank you.
You.